Welcome to our CFP exam prep discussion focused on power of attorney in estate planning. Today, we're diving deep into this crucial legal instrument that often appears on the CFP exam. Let me share with you the essential concepts and common pitfalls that many candidates encounter. Let's start by understanding what power of attorney really means. A power of attorney is a legal document that enables someone, known as the principal, to authorize another person, called the agent or attorney-in-fact, to act on their behalf. Think of it as delegating your legal authority to someone you trust. For instance, if you're traveling abroad for an extended period, you might want someone to handle your financial affairs back home. Understanding the timing aspect is absolutely critical. A power of attorney automatically terminates upon the principal's death. This is a point that frequently trips up exam takers. Many candidates mistakenly believe that an agent can continue to act after the principal's death. The authority ends immediately at death, and then the executor or personal representative of the estate takes over. Now let's break down the two main types of power of attorney. A general power of attorney grants broad authority to the agent. The agent can perform almost any legal act that the principal could do, such as managing bank accounts, signing checks, selling property, and handling investments. For example, an agent with general power could decide to sell the principal's vacation home or restructure their investment portfolio. On the other hand, a limited power of attorney restricts the agent's authority to specific actions or transactions. It might be limited by time, scope, or both. Consider a situation where someone grants their accountant a limited power of attorney just to file their tax returns, or authorizes a family member to sell a specific piece of real estate. Here's where many exam takers make mistakes. They often confuse general power of attorney with durable power of attorney. While a general power of attorney deals with the scope of authority, durability refers to whether the power continues if the principal becomes incapacitated. A non-durable power of attorney terminates if the principal becomes mentally incompetent, while a durable one continues. Another common exam mistake involves springing powers. A springing power of attorney only becomes effective when a specific event occurs, typically the principal's incapacity. Exam questions often test whether candidates understand that these powers aren't immediately effective upon signing. Let me give you a practical example that often appears in exam scenarios. Imagine a question about Sarah, who granted her sister Jane a general power of attorney to manage her affairs while Sarah is working overseas. The question might ask, what happens if Sarah becomes mentally incompetent due to an accident? Unless the document specifically states it's durable, Jane's authority would terminate upon Sarah's incapacity. Remember these key points for the exam. The agent's authority must stay within the scope defined in the document. The principal must be mentally competent when creating the power of attorney. The principal can revoke the power at any time as long as they're mentally competent. And most importantly, all powers cease at death, regardless of their type or scope. These concepts frequently appear in questions focusing on comprehensive financial planning scenarios, right, where you'll need to evaluate whether a client's existing powers of attorney align with their overall estate planning objectives. Make sure you can identify the type of power granted and understand its limitations.